In this video, I want to tell you about the California Consumer Privacy Act, or CCPA, and why you should care about it if you're in HR or do people analytics, even if you don't live in California. Back in 2018, California passed a privacy act that gives protection to consumers and has some similarities to the European Union's GDPR, or General Data Protection Regulations, which you can hear about in one of my other videos on this channel. Now, the CCPA only covers businesses that meet certain qualifications, and so some people have even called it GDPR light, but it is still a major move forward in terms of people data privacy. It covers a consumer very broadly as any natural person who is a California resident. Natural person just meaning the legal definition of an individual human being, which means that it does include employees, regardless of how unnaturally weird you might think some of them are. And here's what it requires. At the time of or before the collection of personal data, companies must notify California resident employees as to what categories of data are being collected on them and for what purposes they will be used. And if a company wants to collect new kinds of data on the employee or wants to use the data for a purpose not originally communicated to the employee, then they will have to inform and get the consent of the employee for that data use. Additionally, California resident employees have a private right of action if their non-encrypted or non-redacted personal info is affected by a data breach, such as unauthorized access, theft, or disclosure. If the breach was caused by the company's failure to implement and maintain reasonable security procedures. Basically, employees can take legal action and employers could face huge fines if employee data is stolen and they didn't take action to safeguard it. Finally, by the end of 2020, companies are also expected to provide rights of access, the ability to request corrections, and the ability to opt out of the sale of personal information. This last bit on access, correction, and sales opt-out does have an exception written into the Act, making it not required until December 31st, 2020 for employees. I guess the lawmakers realize that companies may need a little minute to get their data systems and processes set up for that last little bit. But these rules will apply for California residents who are job applicants, employees, owners, directors, officers, medical staff, and contractors, all of which are considered employees in this law. So why should you care? Well, if you have California-based employees, you need to start taking action now to ensure that all of your information and consent processes are in place for the January 2020 requirements, and make sure you're ready to provide those additional opportunities for opt-out and notifications necessary for 2021. And even if you aren't working with any people data of California residents, you should use this as your early morning wake-up call. When it comes to laws, my home state of California is a bit of a trendsetter, and you can be sure that similar legislation is likely on its way to you soon. I'm a lover of people analytics, but only when people data is used for good. So while these laws may seem cumbersome and difficult to follow, especially when you're still trying to get your people data strategy off of the ground, it's important to understand how needed and beneficial these new laws like GDPR and CCPA really are to helping create transparency in the use of people data and help avoid unintended negative consequences down the road. I hope you found this information on CCPA useful and that you will subscribe for more videos from me in the future. See you soon.